and start the recording, and then I will start sharing my screen here in just a moment.
Sarah, you're on mute.
Yep, I just unmuted myself. So here we go. All right, so good afternoon and happy Hipaa Huddle Wednesday. So this week we have several questions from y'all. So I would like to first take a moment to welcome all of our new huddlers. If you are new to the Hipaa Huddle, what the Hipaa Huddle is questions that y'all have emailed in that we will answer together as a group. So the purpose is for us to learn from our experts that we have on the call, as well as from other folks that are doing the exact same job that you are, and they will have insights for you on your HIPAA questions as well. If you are new, this is not a webinar. This is an interactive meeting where we will talk to each other. So don't be shy, speak up. We do want to hear from you. And if you do hear from somebody on the call that you want to be introduced to, please let us know. We are more than happy to facilitate those introductions. If you don't know who HIPAA is, we are a software company with an all-in-one compliance platform that helps you manage your entire compliance process, from your policies and procedures to employee training and managing all of your business associate agreements and contracts and so much more. We have unparalleled customer service because our customer service folks have sat exactly where you're sitting. They were working in clinics and hospitals, and now they are here to help you. If you would like more information or would like to schedule a demo, you can visit our website, or you can email Jane, who is also on our huddle today, or you can message Jane directly on this meeting through the chat button, and she will set up a time to show you the software. So getting started, so this call is being recorded. You will receive a link to the call at the end of the meeting. Your mic is not permanently muted. We did mute your mics as you were coming in, but if you want to speak, just unmute yourself and we can speak with you that way. Or you can drop your questions or comments inside of the chat box. Your video is off upon entry. However, you can choose to turn that on so that we can see your lovely face as we speak with you. Or you can choose to keep it off. That's completely up to you. And just remember that the more we all participate, the more that we all gain. So with that, we're going to go ahead and get started. So our very first question is on HITECH, right? So we get this question actually a lot. So do I need specific policies and training to be in compliance with HITECH? And for those of you guys who maybe don't know, HITECH, oops, moved my mouse a little bit too far. HITECH was an update to the HIPAA privacy rule that happened in 2009. With that, it brought like liability to business associates. So we had to update our business associate agreements. It also brought us the breach notification rule. So where we actually had to start reporting our breaches and much more. So so the question is, do you need specific policies and training? And the answer is more, you need to have updated your policies to ensure that they are in compliance with the HITECH regulation. And then on top of that, because back in 2009, we needed to have updated those policies, we should be, sorry about my dog, should be training our employees on those policies. And the same thing is going to happen probably next year when the new proposed modifications to the HIPAA privacy rule come out. And we're going to have to make updates to our policies again and train our employees on what those changes are. So any questions or insights on this one?
Hi, Sarah.
Hi.
I have a question for maybe for Aaron and for our attorney colleagues. You know, my clients kind of think of, they always talk to me about HIPAA, right? And we all talk about your HIPAA track. You're not HIPAA high-tech track. You're not HIPAA high-tech omnibus track. You're HIPAA track, right?
Right.
And we just kind of use HIPAA as sort of the shorthand for everything that you've got to do around data security and privacy. So my question for Aaron would be, you know, where do the HIPAA implementable specifications come from? Is that from the security rule? Is that from the HITECH Act? Is that from the omnibus rule, and so on? And then my follow-up question is that is it important for us to know that? Do we care? Lawyers care. Do the rest of us need to care about where these obligations come from?
That's actually a very good question. Aaron?
Yes, lawyers need to care because, you know, when we put in our business agreement, business associate agreements, we're saying you need to comply with the, you know, the original HIPAA rules and regulations. And then you need to also comply with the additional add-ons that have come from time to time. And HITECH would be one of those add-ons to what we originally saw with HIPAA, right? We didn't have teeth as much before the HITECH Act, and then now we have teeth. And so what we want to do is make sure that our business associate agreements are up to date. So what we need to know is that HIPAA isn't as it existed before 2009, before the HITECH Act came out, before those rules came out in, you know, 2011, 2013. So post 2013 really is where we get all of our omnibus rules that came in, implemented all of the HITECH Act and everything around HIPAA. And so if we are still operating under pre-2013 regulations, then we haven't adequately updated. I still do see business associate agreements, and I see notice of privacy practices that have pre-2013 dates on them that come to me from time to time. And then I know they haven't taken into account where we stand now. So we care to the extent that we know what the rules are now. And if we know what the rules are now and we know what the administrative simplification rules are as they exist now, we should be fine. But as far as having to parse them out, this is HITECH, this is, you know, that's definitely a legal mindset that would need to know that. What's most important is that if you're implementing anything related to HIPAA, that you know what the rules are as they exist now. And like Sarah said, that you're keeping an eye out for those rules that we know likely will be implemented in the next year. So just knowing that this is where we are and that we should be watching out for what's coming next is really the best place for somebody who's working in that operations setting to be. Hopefully that answers your question.
Yeah, specifically things like the encryption standard, like access control standards, like, you know, some of those security implementation specs. Do those date from HITECH 2013? Were those original to HIPAA, or did that come later? I'm just where was the threshold when those things started being talked about more?
Yeah, I would say there started, you know, you always had the security rule, but it wasn't really paid attention to until you had that 2019, really 2013 implementation. And then of course they point you towards what are regular updates out of NIST. So if you're the person that's making sure that you're staying up to date on the security, you're going to want to look to the updates that do come out on a semi-regular basis from NIST and other places to make sure that your password specifications are accurate as of what's being required right now. So I would say, as long as you have an IT person or you have somebody in-house that is paying attention to that, I would just make sure that your IT person is paying attention to that. I'm a business associate, and I recently found out that my IT person, although we had everything internally NIST compliant, he was operating within our systems not necessarily NIST compliant. So we had to go to him and say, no, you have to be NIST compliant when you're touching our stuff. And so that it was interesting because I didn't even think to ask. I just assumed he would know and understand that. So it's just, you know, asking the right questions to make sure that your IT people are paying attention, because really they need to know that these things do evolve over time.
Perfect. Michael, does that answer your question? All right, perfect. All right, so moving on to the next question. Erin and Dina, you will know we get this question so much. What are parents' rights to access their child's mental health records? I would like to make a caveat statement before I even answer this, and this is you have to check your state regulations, because your state rules, a lot of times when it revolves around minor records and children's records, are going to really determine the answer to this question. So how we are going to be answering this is from the federal level at the HIPAA level. You need to double check your state regulations. I know I'm in Illinois. Illinois has very specific regulations on this. Jane's in Minnesota that has very specific regulations on this. So really make sure you're checking your state regulations. Now I see you, Dina. Hi.
How are you?
Good. How are you?
Good, thanks. So I think your point, Sarah, is the more important point, not what HIPAA says, but it's the most important point, is that state law is likely going to govern here, because many states, and I don't want to say most, but I think, you know, a good percentage of states have mental health laws, mental health record laws that are more strict than HIPAA. And when a state law is more strict than HIPAA with respect to the privacy of the information, it's the state law that governs. So I'll tell you what the HIPAA rule says. It's pretty simple. It says a personal representative, which is someone who has the authority to make a medical decision on behalf of an individual, is the one who's got the right to access the record, regardless of, you know, the contents of the record, with the small carve out of psychotherapy notes, which, you know, is an issue for another day. But so under HIPAA, a parent has complete access to a child's health record, but there are all sorts of caveats in the various states, whether it's mental health records, substance use disorder records, treatment sought that a minor can seek under state law without a parent's consent. In many states, those records can't be released to parents without the minor's consent. So state law is really the headline here. So it depends on what your state says about mental health records.
Right. And I think it's important to note too, that a lot of like the states that do have regulations will either state like an age where the patient can consent to privacy, right? So they can say, I don't want my parents to have these records. So you need to make sure you're looking at that as well. And then I know in Illinois, it gets even more specific, where if the minor is a parent themselves, or if they are a pregnant minor, then they have rights to their privacy as well. So it gets very, very specific in some states.
I think you'll see that in most states. And it really, the key is, can the minor consent to the treatment themselves? If they can consent to the treatment themselves, in all likelihood, those records are treated the same way as the consent, you know, as the access to care. And in Connecticut, by the way, if you're 16 or older and you seek inpatient mental health treatment, you're treated as an adult. So it's really important to know and understand what the rules in your state are, you know, related to consenting to care.
Perfect. Thank you, Dina. Okay, so we have a comment from Deborah. I have seen some policies for hospitals that do not offer the patient portal to minors. Is this okay?
That's I mean, these state laws are precisely the reason why parents aren't granted access to the portal for their minor children. In fact, it's my experience that most patient portals where there are a lot of minors, so I have many clients who restrict the age the access age for the portal from 11 to 17. So for patients who are ages 11 to 17, parents can't access the portal for records. And the reason for that is because that age range is the range of ages where the minors can seek care without the consent of the parent, which may mean that those records are confidential. So it's very common.
Thank you, Dina. Erin or anybody else, do you guys have anything to add?
Thanks, Sarah and Dina. It's great to see you. I agree with everything both of you just said. And one other thing that's come up recently is I worked with a care coordination, a behavioral health care coordination team. And one of the things that we really had to start with as a basic is that mental health records, not Part 2 covered records, but mental health records are covered in the same way all other information is covered under HIPAA. So from a basic level, it's not any more or less restricted under HIPAA. So I think it's important to start there because there's still, I think, in some places a perception that mental health records have a different designation in people's minds as far as confidentiality. They don't. Unless they're specifically fall under Part 2 records, then we can, again, a discussion for a different day. But so what we really have to do here is look to the specifics of how the child came to seek the mental health treatment and whether or not the minor was ever asked about whether they were pregnant, whether, you know, they have any other potential reasons to be considered not under their parents' care. So it's really important when we do have minors come in for mental health treatment to just note who they want integrated into their care. You know, last year, the OCR talked about this particular subject in its December 12th notice of proposed rulemaking. And it's, you know, they noticed that it's important for family members to be involved in mental health treatment of all people. So our providers should be asking whether these individuals who are checking in for mental health treatment want to have family members involved, and if they do, who is that? So if the minors are saying, yes, I want my parents involved, then you should be noting that in the record. And if they say, no, I don't, then we should be noting that in the record so that across the board in the coordination of care, we know who to involve.
That's actually excellent, Erin. Thank you. All right, so anybody else before we move to the next? All righty. How do other organizations handle requests from the risk director when he or she wants to be notified of all red flag patient record requests? This question came up because a patient requested records, those records were delivered, and for some reason, the patient contacted an attorney. According to the HIM manager, there were no red flags when the patient requesting records. Now the HIM manager has been told she needs to notify the risk director every time there is a patient record that is high risk or a red flag so they can prepare it. So I think, okay, so to answer this question broadly, we can do, because I don't think there's enough information on why the patient contacted an attorney or what the red flag would be, right? But I think that if I look back to when I worked in the HIM department at the Critical Access Hospital, one of the things that we used, especially if it was like for these record requests, because that's a big part of what HIM does on a day-to-day basis in a critical access hospital. And so we had a checklist that we kind of worked through for each record. And so you can include certain red flags or high risk elements that your organization would define as a red flag into that checklist. That would be one suggestion on how to handle that. How is some other HIM directors handling this type of situation? Okay, so while I wait for y'all to gather your thoughts, another thing that we really should be doing is training our employees, right? So training the HIM staff and the medical records staff so that they would be able to recognize potential issues or red flags with a record, right? Knowing what they need to be trained on what a valid authorization form looks like in order to be able to release the information. If it has a power of attorney and it's the power of attorney that's requesting that record, looking at that power of attorney and double checking that and all of that training. So Rachel, you're raising your hand. Do you have a response?
Well, I guess my response would be, it's the patient's record, so they're entitled to it. Is it just letting the risk director know that the patient got the records?
This I don't know. So it looks like the patient requested the records and then the patient contacted an attorney, right? So you're right, a patient has a right to see their own records, right? So, but with patient, I guess this.
I'm confused by this question too, because I don't understand how a patient exercising their rights poses a risk to our organizations.
Yeah, that's true too.
Sarah, where most of my clients contact me is when they receive an authorization to send the records to a third party, where the purpose of the authorization gives them a red flag. So if I was going to do best practices, is if the purpose line, if there is an authorization, it's going to a third party, and the purpose shows that it is for, say, litigation or something like that, that would be a red flag, right? Right now, individuals can say, I want all of my records for me. And that is just a normal request for information. So I think it goes back to what you said, which is training the medical records people to know the difference between an authorization that has a purpose that looks sketchy, or, some other situation that looks normal. I do also have other situations. I work with smaller organizations a lot of times, and there are, there's enough finger on the pulse in the smaller organizations at times for the medical record people to know, say in a long-term care center, if the patient had fallen, or the resident had fallen, and if records are requested around, say, that time frame, then there could be a red flag of, oh, they want to look into the fall and the injuries related to it. So that would potentially be a red flag. So it depends on the size of the organization as to whether, you might have those, finger on the pulse. But beyond the training you talked about, you can also give your providers a training to give the HIM people notice if there is a risk that came out of the care piece. And that would then make the red flag be there if somebody requested records around that time frame. So that's the only other thing I could think in relation to this question that could be helpful.
Erin, this actually makes me think of information blocking as well, because underneath information blocking, a patient can request their own records and not even fill out that authorization form. And the organization will have no knowledge as to why the patient is requesting the records.
Right.
So yeah, it will be very difficult, I think, when patients are requesting their own records to identify red flags moving forward now that we have the Cures Act.
Unless the providers are giving the risk people an idea of what patients they ran into issues with. And so that those requests could be matched up with potential risk areas. So, yeah.
I think that's a great point. Okay, so Diane made a comment. The same if a request comes in, might be a potential issue, bad OB, delivery, surgery, we put it to risk. Sometimes transcription will alert if they recognize an issue. We are a CAW facility, so a critical access facility, and being small, the staff in this department pay attention to something that might be risk. Which that's great, Diane, because that's exactly true with the critical access hospital. We're lucky because we know our patient population so much better and we can actually pay attention. And then should we not have patient fill out a release form, we are still doing this. Underneath information blocking, you are not supposed to be doing that. So they should not be filling out a release of information form for their own information. They're allowed to request the US CDI data points for free. And then like without filling out an authorization form. And then they have the open notes mandate as well. That's part of information blocking, where you are required to provide immediate electronic access to like lab results, progress notes, imaging results, H&Ps. There's a few more things there on that list that you need to provide to them electronically at no cost to them, and you cannot hold it for review. So if there's a lab result that the provider hasn't reviewed yet, you're not allowed to hold that before you can release it to the patient.
Just one clarification on that, Sarah, and that is that while you can't force someone to complete an entire authorization form, release of information form to get their own records, you can have a policy that requires them to give you something in writing. Now that is up for possible change in the notice of proposed rulemaking, but we're still a year or two out from having that happen. So you need to make sure, if you're using a release of information form for documentation purposes, just to know when somebody has asked for records, that you're not requiring that they fill out the purpose, because they cannot be required to tell you why they want their own records. And so this is, I'm focusing just on HIPAA for a second, and what the rules under HIPAA say. So if you're using a release of information form, you're not alone. Many providers are doing it. You have to have a policy that requires it. You have to make sure your patients are aware of that policy. So stick it in your notice of privacy practices. And you can't require that all of the sections be filled out. It's really just the name and contact information, the method of delivery, and their signature and date, and exactly what information they want.
So you can still have them fill that out even under cures? Because I guess I had a different understanding.
What do you mean under cure? So there's no
under information blocking.
You can't force them to fill out an authorization form. And Erin, jump in here. I see that you had your mic off. You can't force them to fill out an authorization form to get access. But remember, information blocking is only about electronic health information. So they should have access to the portal if portal access is available. But Erin, what are your thoughts on what the information blocking rules say about the use of the release form?
Yeah, so if I'm just going to give an example and then I'll follow up with the example. If I am a patient and I send an email to my provider and I say, provide the information, that is written in, that gives them everything that they need to know to do it. They can't come back around and say, well, it's our policy, you have to fill out an authorization. So, essentially they can have a policy that says we need written requests from you so we get it right. So the reason to get the written request is to get it correct. And the reason for that is because the whole idea behind information blocking is to reduce delays in treatment, right? So if you already have in writing from me what you would need on an authorization, then you shouldn't be asking me again for that information for your policy purposes. So there needs to be leeway built into policies that say, we prefer them to fill out an authorization, but if we get it in writing in some other way that gives us the same information, that suffices. So we really just need to look at the reasonability of what we're doing under the Cures Act and make sure that our policies don't cause information blocking, which would be a potential cause and delay of treatment because we're asking for additional information or additional form that we don't really need. So, we have to train our people to say, it's great if somebody will fill out an authorization, but if they've already sent us the request by some other way and we can do what they've asked us to do, taking that additional step could be information blocking. So we just have to say, we're going to accept this in lieu of an authorization. And that would be your safest route there, is adding that additional piece to your HIPAA policies.
And I think we're going to get clarity on all of this once we get the final rules that come from the changes to HIPAA, because I think they're going to try to align some of the HIPAA language with the information blocking rules language. Remember, information blocking is only electronic information. HIPAA is everything else. And there are some pieces of them that don't fit all that well right now. This is one of them. And this is where one of the proposals is that a patient could make a verbal request, and there's been a lot of pushback on that. So I think that hopefully they won't approve the verbal request because we have issues with verification and other things, but we will see some better alignment, I think, with the information blocking rules.
Where people are going to get themselves into trouble is if they stand hard on, we need an authorization, and for some reason that delays treatment. That's ends up being clear information blocking. And then, say a complaint gets filed, it's like, that's where they could use you as an example. And that's where we don't want to be right now.
Right. Right. All right. So great information. Thank you, ladies. I think Jane wants to now show us what the checklists look like. So inside of the HIPAA application. So I'm going to let you take it away, Jane.
All right. So our checklist function in the HIPAA platform, for those of you who have not seen our platform before, is going to line up with what Sarah and Aaron were mentioning on if there is something for you to be able to compare, some questions on what might be a red flag. I know this person who had submitted their question via email wanted to prepare something to share with the employees who would be releasing information. So they could check mark if something might be considered a red flag or not. So we have this checklist function in the platform. You'd be able to assign this to those employees who you want to check this list. And their responses would actually go directly to the risk manager or whoever you put into the platform as the administrator. So you could have this readily available for them to check, and then you'd also be able to see their responses and even assign it to a certain, patient so that you can see the responses by the request.
And Jane, the checklist isn't in there yet for each organization, correct? They would have to create a checklist like this based upon their state laws that apply to them. So they could have what's checklist for, say, Illinois, one for, say they were multi-state, they could have Illinois, Wisconsin, and then they could have, here's your Wisconsin checklist, here's your Illinois checklist, and it would apply to the state laws that would apply to that patient.
Yes, exactly. So this is a checklist that Sarah and I wrote up. We do know of a client who's using it similarly to this, but these were just our examples of red flags. And you are able to make as many checklists as you'd like. So that way you could name them, like you said, based off the state, or, so that your employees know which checklist to compare it to.
Yeah, and the OCR loves when they see, like, if they ever come in and investigate you or do a corrective action plan with you, they love when you have like checklists and cheat sheets and posters and all of that. So this is actually a really good thing to be utilizing. So, all right, so moving on to our next question. Here we go. So, sorry, here we go. Move, there we go. What should I do when staff members access PHI when they have no reason to? Do you have a policy or procedure specific to this? So it's really important that your employees know what your minimum necessary policy is. So you need to have a minimum necessary policy. And then for electronic access, you need to have policies on how they're going to access your data and how you're going to be monitoring that, right? So those are the requirements for HIPAA. And then you should also have a sanction policy so that when they do something like this, they access protected health information that they don't have a reason to, you have a guideline for how you are responding to this, because this is a violation of HIPAA. If I am accessing PHI and I have no reason to, I'm not involved in the care or the healthcare operations for that patient, and I'm accessing that data, then I am violating HIPAA, and I am more than likely violating my organization's policies as well. And so you need to have a sanction policy that kind of guides you on what the next steps are, right? Maybe it's a verbal warning. Maybe it's an actual write-up. You're getting retrained. How are we preventing this from happening in the future? Those are the things that you need to do. I mean, Michael just made a comment. It's a big deal. It is a very big deal when staff accesses PHI that they have no reason to. So, and this is most common, like when we have a celebrity in our hospital or clinic, or we have somebody of very like high importance, or we have like one of our neighbors, our family members that comes to our clinic or hospital, and we're wanting just to check up and see how they're doing. All of that is a violation of HIPAA.
And I'd add to that, Sarah, that in your policy, so yes, everything Sarah said is absolutely correct. You need a sanctions policy, but you also need to make sure that you're applying that evenly across the board. Mm-hmm. And so it means you've got to have a policy that's specific enough about the types of incidents that would result in a written warning versus termination. And let me say this, I do know of hospitals here in this state who have a one strike and you're out policy. They terminate employees for improper access to patient records. You also have to be aware that your folks are doing this, whether you think they are or not, they're doing it. So you've got to audit your records. You have to be proactive about looking at your access to your patient records. Things like not only celebrities and criminals, as Michael pointed out, which is absolutely true, right? People are looking at the record. If any of your employees are also patients, their fellow coworkers are looking at the records. So you should be doing an audit to determine what's happening. And that's the only way that you can dictate the culture at your organization and make clear that this is not acceptable conduct and that you take these things seriously and then you impose the sanctions.
Absolutely. And it gets really interesting too, because there's also some interesting situations. So I don't know, maybe this was like a year ago, I had this conversation with Aaron where we had a client who had a provider that before he would accept a referral patient, so he was a specialty provider, and before he would accept that patient as a patient, he would look at the medical records to determine whether or not he was going to accept that patient. And he wasn't just looking at the clinical treatment records, he was looking at the payment history. He was looking at everything to see everything he could about that patient to determine whether or not that patient was a good fit for him. Whereas that's not exactly a breach of HIPAA, it borders on it. And so you need to think of situations like that as well when you're creating your policies and the culture in your organization, like Dina stated.
Sarah,
something
also,
I think practice managers.
I'm sorry.
Something I think practice managers should really be thinking about is, as you said, this is happening at your organization, mm-hmm. as I think, and how it shakes out depends 100% on what your policies and your training is. If you've got good policies, if you've got good training, if people understand this, they're the ones who can be held personally responsible under HIPAA. If you're not providing that kind of training, they can realistically say, hey, nobody ever told me that this was an issue. If they can say that, the liability is going to land 100% on your organization. And we have seen enforcement activity go both ways. We have seen individuals literally go to jail over this. We've also seen employers being held responsible for the misconduct of their employees because they never trained them, they never had policies, they never had sanctions. It was just a free-for-all. You can't hold them responsible if you don't train them.
So Sarah, a question just came in from Christian, and it's something I know that Michael works with people on too, but we're talking about pre-HITECH and post-HITECH. Before the HITECH Act, we didn't really do a lot of auditing to make sure that we didn't have breaches, et cetera. And now we have to take responsibility for our medical records, especially our electronic medical records. There should be a process, there should be a policy and a process by which you do regular auditing of just looking to see if records are being accessed and who they're being accessed by. And then there's also, if there is an incident in town, like a criminal incident that everybody knows about, or there's an employee that's having issues, or there's a celebrity, you should be auditing who is looking at those records electronically during the time of care, before and after the time of care, to see if the appropriate people are looking at it. So you can actually do specific audits related to specific individuals who are in the news, and then you can do general audits. You should be able to do that through your electronic medical record system if you have one. And so that should be talked out with your IT people and the people that manage your system. So those audits should be able to be done. They've been in most electronic medical record systems for years, and it's just getting a policy in place and identifying who's going to do the audit and who's going to look over the audit results. So that's, and I know that Michael can help you not only figure out if you've got the right policies and procedures in place to do that, but also he can help you get to people if you don't have the right people helping you with that process. So that's who I would suggest on that. But the other thing I wanted to say is, getting back to this question in general, when I get questions like this, what I know is that the people who are doing the training of and onboarding of employees and the annual training of employees are not doing the appropriate training if this is an issue. Because for those organizations that do good training on what you should and shouldn't be doing under HIPAA, you don't have lots of issues like this. You might have rare issues where there is like a criminal incident or something like this, but this sort of question, like, what should I do when staff members access? It almost seems like it's saying that it's a regular occurrence. And if so, then you're not doing the training you need to do. The OCR, if there is a complaint, will see that. And you need to make sure that it's not happening. So going back to Michael's original comment, this is very serious and it needs to be addressed at your onboarding and training level with all employees.
And in terms of when to do an audit, just one quick additional point. It should be part of your HIPAA investigation process. So if you're looking at an incident and you think, oh, maybe this is something that, you know, other folks are looking at the record and they shouldn't, let's go ahead and audit that record. Or if you have an incident, I had a client with an incident recently when a patient came in who there was a restraining order against him from one of the staff members who was in the back. And everyone started looking up this patient's record to figure out who he was. So we knew that when this incident occurred and we learned that there was something going on, we said, look, we've got to audit the record and we have to see who was looking at the record. And sure enough, 3 of the 6 people who looked at the record had no job-related reason to look at the record. So you should be thinking about auditing as part of your investigation process.
Right. And to answer, so I know Kristen's also a critical access hospital, right? And so she asked how to do a random audit. And honestly, Kristen, like when I'm just going back to my HIM days, right? We didn't do random audits. We did structured audits. And we did them both ways, right? So we did them like how Aaron stated, because we were close to a military base. And so we had high profile folks that came to our facility. And so we regularly audited those folks. We regularly audited employee records, and then we would choose employees at random to look at their activity to make sure that there was no flags. So we weren't necessarily, except for like those specific issues that I mentioned before, we weren't auditing patient records as much as we were auditing employee activity. And I think both of those methodologies actually helped us to stay on top of issues like this, which we had issues like this that happened relatively frequently. And if you're not doing the audit activity, you're not going to spot it. And again, like Michael said, this is a very serious issue. So, all right. And now speaking of breaches, Jane's going to show us one more demo of HIPAA before we get to our next question.
While Jane is setting up her screen to share, I want to let everyone know that we have a poll that I've just launched. So take some time to answer that, please.
All right. So in the event that you are having a breach at the organization, for those of you who have not seen our breach management module, we do have an assessment tool to help you decide the level of risk of a breach or an incident. But in these types of situations that we're talking about, if there is a breach and it only affects a few patients, you're still going to need to log it. It just depends on the time frame if it affects many. You'll want to collect all of this information. And what I think that HIPAA helps with a lot is actually the actions taken, helping you fill this out. Because like we mentioned, just doing annual training on these topics is not going to suffice. And you'll also need to show that you've taken actions, either that's assigning out a video, having them read through the policies, whatever actions you've taken in relation to this breach. So once you've logged all your breaches, I will show you there's a place to export this when the time comes to submit your annual report to the OCR. But for those actions taken, one item you can do in HIPAA is actually assign out for somebody to read through the policy. Now, most of our clients will set this as recurring so that this policy is required to be read by your employees on a certain frequency, whether that's once a year, once every 6 months, you can choose. And then they will essentially be able to sign off that they have read through the policy. And this is especially important if you are updating your policies to then make sure that this is being reviewed in a timely fashion. Another action that we've been talking about for this question is actually assigning out those training videos. So while most of these videos will be watched by our clients' employees, at some point during the year, actually assigning these out periodically. These videos are between 5 and 11 minutes long. So you can assign out just these certain topics as a refresher. And then there's also a quiz that can go along with it. So these are just some ideas on ways to refresh this information. Because like Michael mentioned, there's the OCR is still going to look back at your actual training and your policies and that you're reviewing them and not just that you're auditing, but actually providing the right material for your employees to succeed.
Jane, can I ask a question about the product?
Sure.
This is really cool. And I'm just thinking about it for some clients. When you're recording the action taken, do you provide any guidance on when the action taken might be enough? That we've mitigated this and it's not really a reportable breach. So for example, we handed somebody the piece of paper and they handed it right back. They didn't take it away or take it home and we recovered it. That's part of the steps you have to follow to determine whether it's even a reportable breach. I wonder if the platform does anything like that, because that's something that confuses a lot of my clients.
Right. So here's where they would do that, right, Jane?
Yeah, go ahead, Sarah. You can talk through this tool. I would say most people honestly give us a call, but we're still going to help you walk through this tool. So yeah, Sarah, you can kind of talk.
So you would say yes, yes, no. So say no there, and then we would walk through, right? So if we answer low to these other last two here, right? Those are the 4 factors that under the omnibus rule we have to answer. So we would actually just hit log incident instead of log breach. And it's still gathering all the same information, but we just now know that this is an incident, because once we log all this information, and then we go and look at our breach report, our breach incident report, right? We would just toggle to incident and we would be able to see here we have no incidents, but that's how we would be able to look at it, and we can filter everything out there.
And Sarah, it actually goes back to what I put in the chat, which is we're really looking at unauthorized access and how do we determine whether the information was actually accessed. If they couldn't have retained it, and there wasn't a way in which the information was going to continue on to be passed to someone else because the individual couldn't have retained it, then that's really going to be a situation where there's not actually unauthorized access because the person couldn't have retained it. So if I leave something on my desk and you glance at it, but it's clear that you didn't necessarily look at it and you couldn't have retained it, then I can just log that as we need to retrain people on where they're leaving stuff, but we don't need to report it as a specific breach. So those are incidents where we have the no unauthorized access. That's where we determine there's a really low risk there, that we can still determine something happened that made us go and have to do this process. So we need to take a step back and say, what happened that made it so that you handed the piece of paper to someone, or what made it so you left it on your desk? And those are probably things that if we address them, this won't happen in the future. So what we're just determining is whether or not we need to report it. And we also need to determine the issues that caused it to happen in the first place. So this tool will help you do both.
Perfect. Thank you. All right. Getting back to our, oops, there we go, share. Last question for this month, which is, can someone who has been the power of attorney for someone else revoke that responsibility by informally writing a short note and signing it and giving it to the healthcare organization? This note was literally on a notepad saying, I revoke the responsibility of being the power of attorney for my grandfather, John Doe, on this date, January 1, 2021, signed by the person. There was nothing notarized. And how can someone hold someone responsible for this? I don't know if there was another POA on file. My opinion, this is not a HIPAA question.
That's going to be governed by state law entirely.
Yeah, I was like, this one looks like it would be very tricky. Yeah, because power of attorneys are always tricky to begin with. And then somebody wanting to revoke it at the healthcare organization, that seems even trickier.
Right. And just to be helpful here, I always tell clients, the type of authority granted in a power of attorney, we have to talk about, like, what's the authority, right? I could give a power of attorney for someone to be able to pick my nose and say that's the limit of what they can do. And that's my power of attorney. They can't do anything outside of that. So really, it not only depends on state law, but the documentation will give the specifics of the grant. So what the staff who are dealing with power of attorneys need to be trained on is really reading the document, figuring out what the grant of power of attorney is, and then in application to a revocation, getting clarity of what authority they want to not do anymore. I would say in any given case, you can't cause someone who has a power that has been granted to them to do it. The only place in which somebody can actually be held responsible for doing a power that was granted to them is in the case of a guardianship, where a court said you actually have this responsibility, not you have the ability to have that authority. And so in that particular case, if they choose not to do the responsibility of the guardianship, they can get into trouble. But you can't cause somebody who has agency granted to them to actually do it if they don't want to. So what we need to remember in these particular cases is if somebody says, I'm not going to do it, then we need to look to what was granted, why we're seeking them to help in that scenario, and whether the patient has the ability cognitively to determine that they want somebody else to do it. If they don't, and the patient's incompetent, then maybe we look to proxy laws that are in our state, which a lot of states have, that we can help find a proxy for that person to make decisions, or we look towards guardianship laws, depending again on your state, which one is in state law that your facility uses the most. So what we need to do is understand is we can never force somebody to do something that they're permitted to do.
It's a great point, Erin. Thank you. All right, so that wraps up today's HIPAA Huddle. I would love to give a huge thank you to Erin McLean, who is the principal at Compliance Stride, which is a consultancy group. Erin is also a healthcare attorney that is licensed to practice in a lot of states, including Wyoming, Montana, South Dakota, and I'm probably missing some. So thank you to Aaron. Also, a huge thank you to Dina, who is a healthcare attorney and consultant that works out of the state of Connecticut. She works with a lot of FQHCs and is absolutely amazing. And then a huge thank you to Michael Herrick, who is a security and compliance consultant and helps to do security risk assessments. So huge thank you. If y'all would like to hear from any of our experts that were on the call today, please let us know. We would be happy to facilitate an introduction. I would also like to thank Jane for showing us the HIPAA platform. If you would like to see a more in-depth demo of the HIPAA platform, please contact Jane. Her contact is on this slide. And remember that compliance is quality patient care. Thank y'all so much.
Thanks, Sarah. Bye.
Bye, y'all.